How you doing, Mr. Altman? It's a very extensive, I'm quite sure you can hit the 5-minute rule.
Well, what I'm going to do is totally let you off the hook with all those exhibits now that I see how this works.
Thank you.
Okay. I didn't come in to trash any personalities. I've never met anybody in the room before. I'm not part of any group. I am a 54-year-old guy who lives in Florida. I was a jazz musician in New York, and I have run afoul of the system, and my life has been turned into a nightmare, which I'm going to tell you in the 100-second version. And the DDC has stood down and allowed an unethical attorney to torment me. And I will leave it to you to decide whether I'm just a disgruntled litigant or whether I have something valid to say. Okay? Here's my story in a nutshell. This has been going on for 8 years. I'm going to try to give you the 120-second version, Senator. What happened to me is that I have a child who's now 15. In 2001, there was family court issues. I hired an attorney, Richard L. Gold of Morelli & Gold. You can imagine that I'm not in love with him. I wouldn't be here talking about this, but I'll spare you a character assassination and try to stick to the facts. In 2006, after 4 years of family court, my relationship with him soured, and I owed him $20,000. A fee dispute ensued, and I took advantage of the Part 137 law in New York State, 22 NYCRR 137, which allows for mandatory arbitration if the client demands it. And I demanded it. I did not want to go to trial. I live in Florida. I'm not an attorney. The arbitrators hated Mr. Gold, and they told him not only to waive the $20,000 that I allegedly owed him, but they told him to refund an additional $5,000. And Mr. Gold did not do so. I called the disciplinary committee, and I said, this man has my money. And the disciplinary committee said, this is a concern for us, please make a complaint. And I did. And at that time, what happened is that, well, I don't want to get into all the details because it will be an hour, so I'm going to try to keep it to 5 minutes. What happened in a nutshell is that Mr. Gold's retainer said that should there ever be a fee dispute, and should Altman choose arbitration, as is his right pursuant to New York law, that arbitration will be binding upon Altman and the firm. Well, Gold sued me in Supreme Court of New York, and I will quickly get to the DDC's role in this, but give me a little leeway to tell the story, okay? Gold sued me and asked the Supreme Court to award him $35,000. I, who am not a lawyer, made a motion to dismiss pre-answer and said, Your Honor, this is an illegal and unethical misuse of the Supreme Court. There's already been an arbitration, and here is Gold's retainer agreement, and it clearly says the arbitration is binding. Well, Gold made opposition to this, and he said, yeah, the word binding was in the retainer agreement, but it was a special use of the word that meant non-binding. Now, the judge did not buy this, but on June 30th, 2008, in a landmark decision, which is featured on the front of the New York Law Journal with the judge's photograph, Justice Carol Robinson Edmeade ruled that although the word binding is suggestive of binding, that Gold was free to vacate the $25,000 award and start an entirely new trial and drag me to New York. I would never have hired him if I had known that the retainer was a trick. And she ruled that the reason for this is because Gold himself had not used a super secret Boy Scout password encoded form from the Office of Court Administration that I, as an unrepresented consumer, could have known nothing about. Well, the DDC stood down on this. I laid it all out to the DDC. They I've given you the exhibits, which I cannot drag you through in 5 minutes, and I will mercifully not.
But this was I guess was a judge's determination with respect to.
It was a judge's determination after the DDC. I'm telling the 5-minute version, so I'm a little out of sequence. After the DDC stood down and said there appears to be pending litigation on this matter. Well, I wrote back to the DDC and said, look, I know there's pending litigation. That's part of my complaint. This is an unethical litigation. And you guys have all the jurisdiction in the world to deal with this here and now, before the litigation goes on. I cannot quote you chapter and verse, Senator, but the DDC's rules say that they can pursue issues even if there's pending litigation, that they are not hamstrung by the fact that there's pending litigation.
So the DDC did not investigate because there was a pending litigation?
Correct. They closed down. They closed the investigation. And I wrote to them and I said, with all due respect, if you close every ethics investigation that has pending litigation corresponding at the same time, what you're doing is creating a rule so that attorneys who are accused of an ethics violation must bring lawsuit against the client who accused them, because that's the automatic, the DDC will stand down. And if the attorney is unethical enough to keep playing this game in a war of attrition and finally wear the client down, as Richard Gold is trying to do to me, well, then he wins. No, the DDC does not find this to be unethical. Now, the DDC's own rules forbid what Gold did. Gold, as a matrimonial attorney, is not allowed to have trick wording in a retainer agreement regarding fee arrangements. Now, I'm not going to quote chapter and verse, that attorneys cannot lie to clients, and they have a fiduciary relationship. Let's put all that aside. The specific rules of the DDC say, of the ethics rules, say that a matrimonial attorney must set forth the fee arrangements in the retainer agreement in plain language. Now, how on earth is binding meaning non-binding in plain language?
So the DDC never took any action?
The DDC never took any action. So now I will try to give you the punchline. Not only did it later turn out that the form was never even available, the website that the form was supposedly on wasn't available, but I made a reply to Gold's DDC opposition, which was substantially the same as what he made in court. He said, yeah, binding, but it meant non-binding. So what I did is I said, okay, let him have that. What about the fact that he lied in court? He took me into the wrong court. He perjured himself. Here are the transcripts. What about the fact that he puffed up the bill and then knocked it down with courtesy discounts and then went after those courtesy discounts when he found out I wasn't happy with his services? I could go on with 2 or 3 more examples. The DDC never submitted these allegations to Gold. So here are the 4 ways that the DDC specifically stonewalled me and whitewashed the case, which is supposedly still pending. My litigation in New York is still pending in front of Justice Edmeade. It has turned my life upside down. But to be precise, the DDC, the first thing they did is they wrote me a letter saying there's pending litigation, so we're closing the case. As I said earlier,
That's right.
that does not follow their rules. Second, they did not tell me the case could be reconsidered. Their rules require that they notify me of this. Third, they said that there was pending litigation in related matters. That was not true. Okay? And fourth, to this day, I have been in touch with Sherry Cohen, who has told me that the reconsideration is still pending. And to this day, they have never submitted the additional allegations to Attorney Gold.
Where are the other 2 senators?
Basically, the other 2 senators had commitments. This is my colleagues coming in and out because, this is during the day. We have other committee meetings and everything else going on. So you have the chairperson here who's, I'm in charge of the committee. So as long as I don't leave, you're all right.
Well, I want to take a second to apologize to the audience. I'm a little heated, and I am trying as best as possible to knock an 8-year story down to a few seconds.
No. I understand it, and this is something, since your litigation is still pending,